Item C. Issues for consideration. Para 36. Having heard the learned counsel and gone through the materials and record, the following questions of paramount constitutional importance fall for our determination. Number 1. What courses of action are available to the governor in exercise of his powers under Article 200 of the Constitution? Item 1. Whether the first proviso could be said to provide an independent course of action available to the governor in addition to the three options provided under the substantive part of Article 200. Item 2. In what manner the expression, quote, the bill falls through unless the procedure under the first proviso is followed, end of quote, as used in Nalluri Basavaya Chowdhury, quoted sutra, should be construed. Item 3. Whether the decision of this court in the state of Punjab, quoted sutra, could be said to be per incuriam for not having taken into consideration the observations made in previous decisions rendered by larger benches of this court. Item 4. Whether the scheme of Article 200 of the Constitution envisages the exercise of absolute veto or pocket veto within Article 1. Section 2. Whether the governor can reserve the bill for the consideration of the president at the time when it is presented to him for assent after being reconsidered in accordance with the first proviso to Article 200, more particularly when he had not reserved it for the consideration of the president in the first instance and had declared withholding of assent thereto. Item 1. Whether the reservation by the governor for the consideration of the president of the 10 bills which were repassed by the Tamil Nadu State Assembly and presented to the governor on 18th of November 2023 is erroneous in law and hence liable to be set aside. Section 3. Whether there is an express constitutionally prescribed time limit within which the governor is required to act in the exercise of his powers under Article 200 of the Constitution. Item 1. How is the absence of an express time limit in Article 200 to be construed for ascertaining the manner in which the governor is expected to exercise his powers under the said provision? Item 2. What is the import of the expression as soon as possible appearing in the first proviso to Article 200? Item 3. Whether a time limit can be prescribed by this court for ensuring that the exercise of power by the governor under Article 200 is in conformity with the object of expediency underlying the scheme of the said provision. Section 4. Whether the governor in the exercise of his powers under Article 200 of the Constitution can only act in accordance with the aid and advice tendered to him by the State Council of Ministers. If not, whether the constitutional scheme has vested the governor with some discretion in discharge of his functions under Article 200. Item 1. How has the role of the governor been envisaged in the constitutional scheme? Item 2. Whether the governor enjoys a certain degree of discretion in discharge of his functions in contrast to the president. What is the source of such discretion, if any? Item 3. Whether the deletion of the expression in his discretion from Article 175 of the draft Constitution imply that the governor has no discretion available in the exercise of his powers under Article 200. Item 4. Whether the observation of this court from B.K. Pavitra quoted sutra, quote, a discretion is conferred upon the governor to follow one of the courses of action enunciated in the substantive part of Article 200, quote, could be said to be per incuria for having failed to notice the position of law as laid down by the larger benches of this court. Section 5. Whether the exercise of discretion by the governor in discharge of his functions under Article 200 could be said to be subject to judicial review. If yes, what are the parameters for withholding of assent by the President under Article 201 of the Constitution could also be said to be beyond the scope of judicial scrutiny. Item 3. If the aforesaid discharge of functions is subject to judicial review, whether such discharge of functions could be said to be non-justiciable in light of the decisions of this court in text quoted supra, Kesar A. Hill quoted supra, and B.K. Pavitra quoted supra. Section 6. What is the manner in which the President under Article 201 of the Constitution is required to act once a bill has been reserved for his consideration by the Governor under Article 200 of the Constitution? Item 1. Whether the decision of the President to withhold assent under Article 201 of the Constitution could be said to be justiciable. If yes, what is the extent of justiciability that the courts can embark upon while undertaking judicial review of the exercise of powers by the President under Article 201 of the Constitution? Section D. Assent to bills, historical background. Para 37. Article 200 appears in Chapter 3 of Part 6 of the Constitution under the heading Legislative Procedure. Part 6 deals with the states and Chapter 3 deals with the state legislature. The marginal note attached to Article 200 reads Assent to bills, and the article reads as follows. Quote, Article 200. Assent to bills. When a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has been passed by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the President, provided that the governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent, the Governor shall not withhold assent therefrom, provided further that the Governor shall not assent to, but shall reserve for the consideration of the President any bill which, in the opinion of the Governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which that court is by this Constitution designed to fill. Para 38. Section 75 of the Government of India Act 1935, for short the GOI Act 1935, upon which the Article 200 has been substantially modelled, is reproduced here and below. Quote, Article 75 of Government of India Act 1935. Assent to bills. A bill which has been passed by the Provincial Legislative Assembly, or in the case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the Governor, and the Governor in his discretion shall declare either that he assents in his Majesty's name to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the Governor General, provided that the Governor may in his discretion return the bill together with a message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the chamber or chambers shall reconsider it accordingly. End of quote. Para 39. A perusal of both the aforesaid provisions indicates that Article 200 of the Constitution corresponds to Section 75 of the GOI Act 1935, except for the following differences. Item A. The expression in his discretion has been omitted from both the substantive part of Article 200 as well as the first proviso thereto. Item B. The Governor under Article 200 assents to the bill in his own name, unlike Section 75, wherein the assent was to be granted in the name of the Crown. Item C. The expression, quote, if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent, the Governor shall not withhold assent therefrom, end of quote, has been added to the first proviso to Article 200. Item D. The second proviso is a further addition to Article 200 and did not exist in Section 75 referred to above.
Para 40. D.D. Basu, in his commentary on the Constitution of India, quoted in pages 6311, 8th edition, 2009, has observed that the omission of the expression in his discretion from Article 200 signifies that the governor must exercise his power under the article according to the advice of his ministers. Further, the addition of the expression shall not withhold assent therefrom indicates that the governor has no power to veto a reconsidered bill and must assent to it whether it is passed in the original form or with amendments. Para 41. Article 200 is divided into three parts: the substantive part and two provisos. A perusal of the substantive part of Article 200 indicates that the presentation of the bill to the governor is mandatory after it is passed by the state legislature. The same is made evident from the use of the expression, quote, it shall be presented to the governor, end of quote. In the same breath, Article 200 makes it mandatory for the governor to make one of the following declarations: either A, that he assents to the bill, or B, that he withholds assent to the bill, or C, that he reserves the bill for the consideration of the President. Para 42. It is important to note that the expression shall has been used to qualify the three types of declarations that the governor can make upon presentation of the bill to him. Further, the three options provided in the substantive part of Article 200 are connected by the conjunction or, which signifies that the three options are mutually exclusive of each other and the governor can only choose one of them at a time. In other words, the governor cannot assent to a bill and also reserve it for the consideration of the president at the same time. Similarly, the governor cannot declare that he withholds assent and also reserve the bill for the consideration of the president at the same time. Patanjali Sastri, Chief Justice as he then was, observed to this effect in State of Bihar versus Kameshwar Singh, reported in 1952 1 SCC 528 as follows, quote, Para 20. It is significant that the article does not contemplate the governor giving his assent and thereafter, when the bill has become a full-fledged law, reserving it for the consideration of the president. Indeed, the governor is prohibited from giving his assent where such reservation by him is made compulsory. The Constitution would thus seem to contemplate only bills passed by the House or Houses of Legislature being reserved for the consideration of the President and not laws to which the Governor has already given his assent. Similarly, Article 31, Clause 3 must, in my judgment, be understood as having reference to what, in historical sequence, having been passed by the House or Houses of the state legislature and reserved by the governor for the consideration of the president and assented to by the latter, has thus become a law. If it was intended that such a law should have the assent of both the governor and the president, one would expect to find not only a more clear or explicit provision to that effect, but also some reference in Article 200 to the governor's power to reserve a measure for the consideration of the president after himself assenting to it. End of emphasis. On the other hand, as we have seen, where reservation by the governor is made obligatory, he is prohibited from giving his assent. End of quote. Emphasis supplied. Para 43. The first proviso to Article 200 has no application to money bills. For all other bills, it provides that the governor may, as soon as possible, after the presentation of the bill to him for assent, return the bill to the House or Houses along with a message requesting the House or the Houses to reconsider the bill in totality or in sections, or certain provisions thereof. He may also recommend the reintroduction of certain amendments to the bill. The first proviso further states that when a bill is returned with such a message, then the House or the Houses must reconsider the bill accordingly, and if the bill is passed with or without amendments and presented to the Governor for assent, he shall not withhold assent therefrom. Para 44. The second proviso to Article 200 provides that if the governor is of the opinion that a bill which is presented to him for assent would, upon becoming law, so derogate from the powers of the High Court as to endanger the position which that court is designed to fill by the Constitution, then he must reserve the bill for the consideration of the President and not grant assent to it. Para 45. The heart of the controversy before us lies in the interpretation of the substantive part of Article 200 and the first proviso to it. The arguments advanced before us, coupled with the factual situation which we are confronted with, and the broader constitutional and political consequences that an interpretation of Article 200 entails, has opened up before us a treasure trove of questions hidden in the seemingly innocuous and plain language used in Article 200. 46. Para 46. For a better understanding of Article 200, it is necessary that we should first understand the concept of assent to bills, how it has evolved over the centuries, and its importance in parliamentary democracies across the globe. We are undertaking this exercise as Article 200 cannot be understood fully without having regard to the context in which it came to be included in the Constitution. While fidelity to the text of the provision holds paramount consideration in its interpretation, the context is equally, if not more important, more so in light of the fact that Article 200, as it stands today, bears striking resemblance to Section 75 of the Government of India Act 1935 and other important historical documents which were being drafted by Indians during the course of the freedom struggle. Para 47. In Westminster styled polities, the Parliament consists of a lower house, an upper house, and the head of state. The Indian Constitution has also broadly adopted a similar structure, which becomes evident from Articles 79 and 168 respectively. Article 79 provides that the Parliament shall consist of the President and two houses, the Council of States and the House of the People. Article 168 provides that each state shall have a legislature which shall comprise of the governor and either one or two houses as the case may be. In the Westminster system, for a law to be passed by the Parliament, it must receive the approval of all the three elements: the lower house, the upper house, and the head of the state. Para 48. Jessica J. Richardson, in her paper titled Modernization of Royal Assent in Canada, has traced the historical origins of the practice of granting assent to bills enacted by the Parliament in the United Kingdom. She has explained that the practice of signifying royal assent to bills passed by Parliament began during the reign of Henry VI in 1422, who ruled between 1422 and 1471, when the practice of introducing bills in the form of petitions was replaced by bills in the form of complete statutes. This was a time when assent was granted in person. The sovereign would attend the parliament in the House of Lords and give his consent in person. This practice continued until 1541, when the task of signifying royal assent was assigned to a royal commission in order to spare King Henry VIII the indignity of having to give royal assent to the Bill of Attainder, which provided for the execution of his wife Catherine Howard. It was after this occurrence that the practice of appointing Lord Commissioners responsible for giving royal assent developed. In the United Kingdom, the last instance of a monarch giving royal assent in person was in 1854, when Queen Victoria personally assented to several bills prior to proroguing the Parliament. However, in Canada, King George VI gave royal assent in person to bills passed by the Canadian Parliament in 1939 during a visit to Canada. The use of a royal assent ceremony continued in the United Kingdom until 1967, when the British Parliament passed the Royal Assent Act 1967. The said legislation repealed the Royal Assent by Commission Act 1541 and allowed a simple report of royal assent by the speakers of the two houses to give a bill the force of law. Para 49. In the Canadian context, she explains that the royal assent ceremony was inherited from the United Kingdom tradition and was used prior to Confederation in both Lower and Upper Canada and closely resembled the original ceremony used in the United Kingdom. Prior to adoption of the new procedure in 2002, Canada was the only remaining Commonwealth country to still use the traditional ceremony for royal assent. However, taking inspiration from the practice prevailing in other Commonwealth countries, including Australia and New Zealand, as well as several Canadian provinces, the royal assent procedure was modernized by adopting a written declaration procedure. Para 50. One of the first instances where the concept of assent to bills appears in a documented form in the Indian context is the Constitution of India Bill 1895, which is also popularly referred to as the Swaraj Bill. The bill, which is also termed by the academics as the first articulation of a constitutional imagination by Indians, besides incorporating ideas of free speech, equality before law, right to property, etc., also envisaged a machinery of governance and separation of powers, albeit within the British Empire. As regards the legislative structure, the bill proposed that the sovereigns of Great Britain shall reign and the sovereign of Great Britain shall reign and rule over India, and the viceroy shall be the representative of the sovereign in India. It further envisaged that the viceroy would be the president of the parliament and would have the power to veto any law enacted by the Indian parliament and initiate legislation. Article 97 of the bill provided that no bill would become law until it received the sanction of the sovereign. The said provision is reproduced herein below. Quote, Article 97. No bill shall become law unless it has passed by majority through the lower house 3 times and the upper house 3 times, and unless it has obtained the sanction of the sovereign. End of quote. Para 51. A few years after the ideation of the Swaraj Bill, the demand for self-government further found expression in the Congress League scheme of 1916, which was a result of deliberations of the committees constituted jointly by the Indian National Congress and the All India Muslim League. The document envisioned a federal polity, with provincial legislative councils for the provinces and an imperial legislative council at the national level. It is pertinent to note that, as per the scheme, the governor was envisaged as the head of the provincial government, and any bill passed by the provincial legislature had to mandatorily receive his assent before it became law. Further, the document also conferred upon the Governor General the power of vetoing any law passed by the provincial legislature. Any bill passed by the Imperial Legislative Council had to receive the assent of the Governor General before it became law. The relevant provisions in the said document are reproduced herein below. Section 1. A Provincial Legislative Councils. Ellipsis. Article 9. A bill other than a money bill may be introduced in council in accordance with rules made in that behalf by the council itself, and the consent of the government should not be required therefore. Section 2. Provincial Governments. Article 1. The head of every provincial government shall be a governor who shall not ordinarily belong to the Indian civil service or any of the permanent services. Ellipsis. Section 3. Imperial Legislative Council. Item 9. All bills passed by the council shall have to receive the assent of the Governor General before they become law. End of quote. Para 52. In the backdrop of the growing demand for self-government by the Indian national movement and the Montagu-Chelmsford Report, the Government of India Act 1919, for short the GOI Act 1919, was enacted and received assent of the British Crown in December 1919. The legislation introduced diarchy at the provincial level by the introduction of the transferred list and the reserved list. The reserved list consisted of the subject matters on which the governor enjoyed exclusive legislative powers. However, what we wish to draw attention to is the provision contained in the said legislation as regards assent to bills. Section 12 provided that the governor had four options to choose from when a bill was presented to him for assent: to declare assent, to withhold assent, to return the bill to the council for reconsideration, or to reserve the bill for the consideration of the Governor General. Notably, there was no requirement for the governor to mandatorily assent to a bill upon its presentation after reconsideration. Further, the governor had the power to veto any bill passed by the Legislative Council by a declaration simpliciter of withholding of assent. There was also a provision for the lapse of a bill reserved for the consideration of the Governor General if assent was not granted within a period of 6 months. Thus, the concept of both absolute and pocket veto could be said to have been available to the Governor and the Governor General under the provisions of the Government of India Act 1919. The relevant provision is reproduced herein below. Quote, Item 12. Return and reservation of bills. Sub-item 1. Where a bill has been passed by a local legislative council, the governor, lieutenant governor, or chief commissioner may, instead of declaring that he assents to or withholds his assent from the bill, return the bill to the council for reconsideration, either in whole or in part, together with any amendments which he may recommend, or in cases prescribed by rules under the Principal Act, may, and if the rules so require, shall reserve the bill for the consideration of the Governor General. Item 2. Where a bill is reserved for the consideration of the Governor General, the following provisions shall apply. Item A. The Governor, Lieutenant Governor, or Chief Commissioner may, at any time within 6 months from the date of the reservation of the bill, with the consent of the Governor General, return the bill for further consideration by the Council, with the recommendation that the Council shall consider amendments thereto. Item B. After any bill so returned has been further considered by the Council, together with any recommendations made by the Governor, Lieutenant Governor, or Chief Commissioner relating thereto, the bill, if reaffirmed with or without amendment, may be again presented to the Governor, Lieutenant Governor, or Chief Commissioner. Item C. Any bill reserved for the consideration of the Governor General shall, if assented to by the Governor General within a period of 6 months from the date of such reservation, become law on due publication of such assent, in the same way as a bill assented to by the Governor, Lieutenant Governor, or Chief Commissioner, but if not assented to by the Governor General within such period of 6 months, shall lapse and be of no effect unless before the expiration of that period, either Item 1. The bill has been returned by the Governor, Lieutenant Governor, or Chief Commissioner for further consideration by the Council, or Item 2. In the case of the Council not being in session, a notification has been published of an intention so to return the bill at the commencement of the next session. Item 3. The Governor General may, except where the bill has been reserved for his consideration, instead of assenting to or withholding his assent from any act passed by a local legislature, declare that he reserves the act for the signification of His Majesty's pleasure thereon, and in such case, the act shall not have validity until His Majesty in Council has signified his assent and his assent has been notified by the Governor General. End of quote. Para 53. A reading of the aforesaid provision also indicates that at the time of drafting Article 200, the framers of the Constitution not only had before them Section 75 of the Government of India Act 1935, but also Section 12 of the Government of India Act 1919, as well as other possible variations about which we shall discuss in the following paragraphs. However, certain features of Article 200, namely the absence of automatic lapse upon not receiving approval, mandatory requirement for the governor to not withhold assent to a bill which is presented to him after being reconsidered by the legislature, and absence of the expression in his discretion must be viewed in the context of gradual dilution of the role and powers of the governor in provincial governance as the country neared independence. Section I. Concept of assent to bills as envisaged by certain historical documents drafted during the freedom struggle. Para 54. The concept of assent by the sovereign found mention in Section 75 of the Government of India Act 1935 and Article 200 as it stands today is predominantly modelled according to the version which existed therein. However, before we proceed to discuss Section 75 of the Government of India Act 1935 and how it eventually evolved into Article 200 of the Constitution, we deem it appropriate to briefly shed light on how other aspirational constitutional documents drafted during the course of the freedom struggle imagined the presence of assent to bills and made certain modifications to the practice that prevailed in the United Kingdom. Para 55. The Commonwealth of India Bill 1925 that was drafted by the National Convention had a lasting impact on the eventful framing of our Constitution as regards the idea of royal assent. Article 39 of the said bill provided that a bill passed by the Parliament would be presented to the Viceroy for obtaining the King's assent. Similarly, for the provinces, Article 83 provided that the bills passed by the provincial legislature would be presented to the governor for obtaining the King's assent. However, what is relevant to note is that the provisions were not elaborate as regards the procedure and scope of powers of the sovereign while taking a decision on the aspect of assent. Para 56. However, the Nehru Report of 1928 shortly followed the Commonwealth of India Bill 1925 and was drafted in response to the dissatisfaction with the Simon Commission. The report sought to negative the challenge posed by the British that a constitutional document which is agreeable to all could not be drawn by Indians and contained elaborate provisions providing the mechanism for the purpose of assent to bills. Para 57. As regards the bills passed by the Parliament, it was stipulated in the Nehru Report that a bill would not become an act until assent was granted by the Governor General. The Governor General was provided with three options: to signify assent, to withhold assent, or to reserve the bill for consideration by the British Crown. Notably, there was no obligation on the Governor General to signify assent after a bill was repassed with or without the amendments suggested by him. The relevant provision is reproduced herein below. Quote, Article 21, Section 1. So soon as any bill shall have been passed or deemed to have been passed by both houses, it shall be presented to the Governor General for the signification by him in the King's name of the King's assent, and the Governor General may signify such assent or withhold the same or he may reserve the bill for the signification of the king's pleasure. Item 2. A bill passed by both houses of parliament shall not become an act until the Governor General signifies his assent thereto in the king's name, or in the case of a bill reserved for the signification of the king's pleasure, until he signifies by speech or message to each house of parliament or by proclamation that it has received the assent of the king in council, provided that the Governor General may, where a bill has been passed by both houses of parliament and presented to him for the signification by him of the king's assent, or has been reserved by him for the signification of the king's pleasure, return the bill for reconsideration by parliament with the recommendation that parliament shall consider amendments thereto. Number 3. Any bill so returned shall be further considered by Parliament together with the amendments recommended by the Governor General, and if reaffirmed with or without amendments, may be again presented to the Governor General for the signification in the King's name of the King's assent. Para 58. As regards the provincial legislature, a bill passed by the provincial legislature had to be assented to by the Governor before it would become an act. The Governor had two options: to declare assent or to withhold assent. Notably, the Governor did not have the option to reserve the bill for the consideration of the Governor General. However, every bill after receiving the assent of the Governor had to be mandatorily referred to and assented by the Governor General, failing which the act would have no validity. Even after receiving the assent of the Governor General, the act could be disallowed by the King and would thereupon become void. The relevant provisions are reproduced herein below. Quote, Article 37. When a bill has been passed by a local legislative council, the Governor may declare that he assents to or withholds his assent from the bill. Article 38. If the Governor withholds his assent from any such bill, the bill shall not become an act. Article 39. If the Governor assents to any such bill, he shall forthwith send an authentic copy of the Act to the Governor General, and the Act shall not have validity until the Governor General has assented thereto, and that assent has been signified by the Governor General too, and published by the Governor. Article 40. Where the Governor General withholds his assent from any such act, he shall signify to the Governor in writing his reason for so withholding his assent. Article 41. Article 41. Sorry. When an act has been assented to by the Governor General, it shall be lawful for His Majesty in Council to signify his disallowance of the act. Article 42. Where the disallowance of an act has been so signified, the Governor shall forthwith notify the disallowance, and thereupon the act, as from the date of the notification, shall become void accordingly. Paragraph 59. In 1944, the All India Hindu Mahasabha adopted the Constitution of Hindustan Free State Act as an aspirational constitutional document. As regards the procedure of assent by Governor in provinces, the document contained the following provision. Quote, Article 93, Section 1. So soon as any bill shall have been passed by both chambers, it shall be presented to the Governor for the signification of his assent, and he may signify such assent or withhold the same. Number 2. A bill passed by both chambers shall become an act if the Governor signifies his assent thereto, and that assent has been published by him. Number 3. In case where the Governor withholds his assent to a bill passed by both chambers, he shall return the bill for reconsideration with his own recommendations thereto. Number 4. A bill so returned shall be further considered by both chambers together with the recommendations made by the Governor, and if it is reaffirmed with or without amendments by both chambers, it shall be deemed to have been assented to by the governor, but it shall not become an act unless and until the President of the Hindustan Free State has assented thereto, and that assent has been signified by the President to and published by the governor. End of quote. Para 60. A perusal of the above indicates that the governor had the option of either assenting to or withholding a bill presented before him. However, in the latter case, the governor was under an obligation to return the bill for reconsideration with his own recommendations, whereupon the provincial legislature was required to reconsider the bill in light of the recommendations made. Upon being passed again with or without amendments, the bill would be deemed to have been assented to by the governor. However, it would become an act only upon being assented to by the President, who would signify his assent to the Governor. Thus, the President was vested with the power to veto any bill which had not been assented to by the Governor and was passed again after reconsideration with or without the amendments recommended by the Governor. This was in contrast to the position with respect to the federal legislature, wherein no veto power was conferred on the President. The relevant provision read as follows. Article 30, Section 1. So soon as any bill shall have been passed by both chambers, it shall be presented to the President for the signification of his assent, and he may signify such assent or withhold the same. Number 2. A bill passed by both chambers shall not become an act unless and until the President signifies his assent thereto. Number 3. In case where the President withholds his assent to a bill passed by both chambers, he shall return the bill for reconsideration to the originating chamber with his own amendments thereto. Number 4. A bill so returned shall be further considered by both chambers together with the amendments recommended by the President, and if it is reaffirmed with or without amendments by both chambers, it shall be deemed to have been assented to by the President and shall become an act. End of quote. Para 61. One more document that we would like to refer to is the Constitution of Free India, a draft authored by M.N. Roy in 1944. The document proposed a radically different version of assent to bills as distinguished from the scheme prevailing under the Government of India Act 1935 or other contemporaneous aspirational constitutional documents. The document vested no authority in the governor to withhold assent to a bill passed by the provincial legislature or to veto the same. However, the document vested power in the Supreme People's Legislature, which was a joint sitting of both the chambers of the federal legislature, to veto any provincial legislation. However, this veto power was subject to judicial review, and the provincial government was given the right to challenge the veto before the Supreme Federal Court. The relevant provisions are reproduced herein below. Quote, Article 62. The Supreme People's Council will have the right to veto any provincial legislation in the Federal Union on the ground that it is repugnant to the Federal Constitution or contradicts any particular federal law. Either on the advice of the Council of Ministers or on his own initiative, the Governor General will recommend the vetoing of a provincial legislation. The provincial government concerned will have the right to appeal to the Supreme Federal Court against the veto. Ellipsis. Article 91. The governor shall sign and promulgate all laws made by the Provincial People's Council. End of quote. Para 62. What is interesting to note is that the imagination of a provision as regards assent to bills when the country was on the brink of becoming independent from the British rule was significantly different from the previous versions envisaged in times when the freedom struggle was focused more on obtaining greater degree of self-rule while being under the sovereignty of the British Crown, as can be seen in the versions used in the Nehru Report and the Constitution of India Bill 1925. The two documents which were drafted in 1944 and are referred to above indicate that the governor was vested with lesser powers and discretion, and there was a clear inclination towards a more unitary arrangement insofar as assent to bills was concerned. The ideas of judicial review of exercise of veto by the President against a state legislation, mandatory return of the bills for reconsideration upon withholding of assent, and deemed assent upon reconsideration were being experimented with, among others, in the immediate lead up to the framing of our Constitution. Para 63. Besides the aspirational constitutional documents referred to above, it is also pertinent to discuss how assent was envisaged by one of the first indigenous constitutional documents that was implemented in practice as well. Section 15 of the Oundh State Constitution Act 1939, that was purportedly enacted to grant self-rule to the people of the Oundh principal princely state, laid down the procedure for assent to bills. The relevant provision read as follows. Quote, Article 15, Section A. All bills shall be passed by a majority of members of the Legislative Assembly present and voting, and shall become law only on receiving the assent of Srimant Raja Sahib. Item B. If Srimant Raja Sahib in his discretion withholds his assent to a bill which has been duly passed by the Legislative Assembly, he shall return it to the Legislative Assembly together with a message requesting that the Legislative Assembly will reconsider the bill in the light of his recommendations, and when a bill is so returned, the Legislative Assembly shall consider it accordingly. Item C. If the Legislative Assembly accepts the recommendations, the bill shall forthwith become law. But if it rejects the recommendations of Srimant Raja Sahib, he shall have the right to postpone his assent to the bill till the next session of the Legislative Assembly. He can so postpone the said bill for not more than 3 times. If the said bill in its original form is passed by a simple majority of the members present on all the 3 times, it is sent for reconsideration, it shall forthwith become law. End of quote. Para 64. What is interesting to note in the aforesaid provision is that although it vested Srimant Raja Sahib, the king, with the discretion to either assent to a bill passed by the legislature or to withhold assent thereto, yet it made it mandatory for him to return the bill to the legislature with a message requesting them to reconsider the bill in light of his recommendations if he opted for withholding assent. Further, after a maximum of 3 rounds of reconsideration, the bill would become law upon being passed with a majority, regardless of receiving assent of the king or not. Para 65. On the contrary, the Government of Mysore Act 1940 gave the king unfettered powers to veto any bill passed by the Legislative Council. The relevant provision reads as follows. Quote, Article 28, Section 1. When a bill has been passed by the Legislative Council, it shall be submitted through the Diwan to His Highness the Maharaja for assent with a statement of the opinion expressed by the Representative Assembly on the principles of the bill or its general provisions. Number 2. No such bill shall become law until it has received the assent of His Highness the Maharaja. End of quote. Para 66. Having discussed in detail the inception of the concept of assent to bills in the Indian context and its interaction with the indigenous thought prevailing at the time, we shall now proceed to discuss the provisions pertaining to assent as contained in the Government of India Act 1935 and how it was molded by the Constituent Assembly into Article 200 of the Constitution. Para 67. Under the Government of India Act 1935, the Governor was required to act on the aid and advice of the Council of Ministers responsible to the provincial legislature. However, the Governor continued to have some special responsibilities, and he also possessed discretionary powers to act in situations such as prevention of grave menace to the peace or tranquility of the province, safeguarding the legitimate interests of minorities, and so on. The governor could also act in his discretion in specified matters. He functioned under the general superintendence and control of the Governor General whenever he acted in his individual judgment or discretion. Para 68. It is interesting to note that while the framing of the Constitution was being undertaken by the Constituent Assembly, the Government of India Act 1935, as adapted by the India Provincial Constitution Order 1947, was made applicable for the administration of the country. By way of paragraph 3 of the said order, the expressions in his discretion, acting in his discretion, and exercising his individual judgment were removed or deleted from wherever they occurred in the Government of India Act 1935. Paragraph 3 read thus. Quote, Article 3, Section 1. As from the appointed day, the Government of India Act 1935, including the provisions of that Act which have not come into force before the appointed day, and the India Central Government and Legislature Act 1946, shall, until other provision is made by or in accordance with the law made by the Constituent Assembly of India, apply to India with the omissions, additions, adaptations, and modifications directed in the following provisions of this paragraph and in the schedule to this order. Number 2. The following expressions shall be omitted wherever they occur, namely, in his discretion, acting in his discretion, and exercising his individual judgment. End of quote. Para 69. Article 147 of the draft constitution prepared by the constitutional advisor Shri B. N. Rao dealt with assent to bills passed by the provincial legislature and read as follows. Quote, Article 147. A bill which has been passed by the provincial legislature or in the case of a province having a legislative council has been passed by both houses of the provincial legislature shall be presented to the governor, and the governor shall declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the president. Provided that where there is only one house of the legislature of a province and the bill has been passed by that house, the governor may, in his discretion, return the bill together with a message requesting that the house will reconsider the bill or any specified provisions thereof, and in particular will reconsider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the House shall reconsider it accordingly, and if the bill is passed again by the House with or without amendments and presented to the Governor for assent, the Governor shall not withhold assent therefrom. End of quote. Para 70. Article 147, as reproduced aforesaid, made significant departure from Section 75 of the Government of India Act 1935 as follows. Item A. The expression in his discretion was removed from the substantive part of the provision. However, the said expression continued to be present in the proviso to the substantive part. Item B. While Section 75 of the Government of India Act 1935 provided for the sending back of a bill for reconsideration by the legislature in the provinces having both unicameral and bicameral legislatures, Article 147 only provided for such reconsideration in the provinces with a unicameral legislature. Item C. Under Section 75, there was no mandate upon the governor to mandatorily assent to a bill when the bill was presented to him for reconsideration. However, in Article 147, the expression shall not withhold assent therefrom was added in the first proviso. Para 71. 4 months after the draft constitution was submitted by Shri B. N. Rao, the drafting committee under the chairmanship of Dr. B. R. Ambedkar submitted the draft constitution to the President of the Constituent Assembly in February 1948. Article 147 of the draft constitution submitted by the constitutional advisor was adapted with certain structural modifications as Article 175 of the draft constitution. However, in essence, the provision remained the same. Section 2. Debates of the Constituent Assembly on Article 200 of the Constitution. Para 72. When Article 175 of the Draft Constitution 1948 was taken up for consideration by the Constituent Assembly, certain amendments were moved by Dr. Ambedkar that came to be accepted, leading to the adoption of the draft Article 175 as Article 200 of our Constitution. The amendments were: Item A, to remove the expression in his discretion appearing in the first proviso to Article 175. Item B, to exclude money bills from the purview of the first proviso. Item C, to enable the governor to return the bills in all the states irrespective of whether there was a unicameral or a bicameral legislature. Para 73. With a view to better understand the intention of the framers of the Constitution, it is of utmost importance that we turn the pages of the debates that took place in the Constituent Assembly. Para 74. On the 30th of July 1949, Dr. B.R. Ambedkar moved an amendment as discussed aforesaid for the substitution of the first proviso under draft Article 175, which later came to be successfully adopted by the Constituent Assembly. While moving for the substitution and highlighting that predominantly three key changes were sought to be made to the first proviso, he remarked that the words "in his discretion" under the draft Article 175 were sought to be deleted because it was felt that quote, in a responsible government, there can be no room for the governor acting on discretion. End of quote. Sri Bajeshwar Prasad was not wholeheartedly in favor of the changes suggested to the first proviso and contended that they would strip the governor of the power to veto a bill or reserve it for the consideration of the president in his own discretion or initiative, and he would be able to do so only when so advised by his cabinet of ministers. In his opinion, the change also meant that the governor would not be able to veto a bill that has been passed twice by the Legislative Assembly, which he felt was not acceptable. Para 75. Sri Bajeshwar Prasad acknowledged that there are two classes of cases in which a bill can be reserved for the consideration of the President. Number one, where a certain article of the Constitution requires the same, and number two, when the governor is advised by his ministry to do so. However, he advocated for a third category, that is, where the governor would possess the power in his discretion to veto a bill passed by the legislature, irrespective of whether it was passed once or twice by it. He supported the vesting of discretion in the hands of the governor so that he could veto unjust and unsound legislation while also ensuring that there is a check on potentially disruptive legislative tendencies. From his standpoint, the fear of disruptive legislation was not imaginary but real in our country, and he advocated that his proposal was in consonance with the tradition of the centralized system of government that existed in our country until independence. He was of the view that the parliamentary form of polity was a new experiment to the facts of life in our country and it was required to be moderated and regulated. Expressing his lack of confidence in the provincial ministers, he contended that empowering the governor to act in his discretion would not be so objectionable since the governor is also the representative of the government of India and it is by virtue of this position that his views must prevail over those of the state legislature. Para 76. On the other hand, during the course of the debate, Sri Shibanlal Saxena addressed the practical realities of assigning such a discretion to the governor, who is a nominee of the president, especially when the party in power in the province may not be the same as the party in power at the center. In such a scenario, it was his opinion that, quote, it will introduce a very wrong principle to give the governor this power to go against the express wish of the assembly and even of the council. End of quote. Para 77. Sri T.T. Krishnamachari also emphasized that under the newly proposed draft Article 175, more specifically the first proviso, the governor will not be exercising his discretion in the matter of referring a bill back to the House with a message. The governor would exercise his power under the first proviso only upon the advice of his Council of Ministers. According to him, the first proviso was to be exercised in situations wherein the House has already accepted and endorsed a provision, but the ministry was of the opinion that certain modifications are required to be made in the said provision. It is only when such an occasion arises that the procedure envisaged under the first proviso would be resorted to. The Council of Ministers would use the governor to hold up further proceedings of the bill and remit it to the lower house with the message informing the legislature about the modifications sought to be made to the bill by the ministry. He drew attention to the words of Dr. Ambedkar on this aspect and stated as follows, quote, if he construes that this amendment is worse than the proviso in the draft article and that it makes for further dilatoriness in the proceedings of the legislatures in the provinces or the states as the case may be, I would ask him to remember one particular point to which Dr. Ambedkar drew pointed attention, viz. that the governor will not be exercising his discretion in the matter of referring a bill back to the House with a message. That provision has gone out of the picture. The governor is no longer vested with any discretion. If it happens that, as per Amendment number 17, the governor sends a bill back for further consideration, he does so expressly on the advice of his Council of Ministers. The provision has merely been made to be used if an occasion arises when the formalities envisaged in Article 172, which has already been passed, do not perhaps go through, but there is some point of the bill which has been accepted by the upper house, which the ministry thereafter finds has to be modified. Then they will use this procedure. They will use the governor to hold up the further proceedings of the bill and remit it back to the lower house with his message. End of quote. Para 78. The first proviso, according to him, was therefore a saving clause which vested power in the hands of the ministry to remedy a hasty action that they might have undertaken with respect to the bill in question, or it could also be seen as providing some scope to the ministry to take certain additional actions that the ministry feels should be taken in order to meet the popular opinion reflected outside the house in some form or another. Therefore, the operation of the first proviso does not abridge the power of the legislature or the ministry responsible to it. Rather, it further curtails the governor's power from the position that was envisaged in the original first proviso, which is now sought to be supplanted. Para 79. In light of the debate which took place as regards the substitution of the first proviso to draft Article 175, the amendment was put to vote and the same was successfully adopted by the Constituent Assembly. Para 80. On 17th of October 1949, T.T. Krishnamachari moved an amendment that a second proviso to Article 175 also be added, which later came to be adopted by the Constituent Assembly. Dr. B.R. Ambedkar elucidated that the second proviso that was proposed to be moved was a part of the instrument of instructions issued to the governor of the provinces under the Government of India Act 1935. Paragraph 17 of the instrument of instructions read as follows. Quote, without prejudice to the generality of his powers as to reservation of bills, our governor shall not assent in our name to, but shall reserve for the consideration of our Governor General any bill or any of the clauses herein specified, that is, item B, any bill which in his opinion would, if it became law, so derogate from the powers of the High Court as to endanger the position that that court is by the act designed to fulfill. End of quote. Para 81. Such a clause was initially supposed to be included in the fourth schedule that separately contained instructions to the governors of the states. However, since it was considered unnecessary to have such a separate schedule, this particular aspect was sought to be brought in as second proviso to the draft Article 175. A need to incorporate the second proviso was felt because the high courts were placed under the legislative competence of the center as well as the states. Insofar as the organization and territorial jurisdiction of the High Court was concerned, the power remained with the center. However, with regard to the pecuniary jurisdiction and the jurisdiction in relation to any of the matters which are mentioned under List 2, the power rests with different states. Therefore, there could arise a scenario wherein the state legislature would enact a bill which would derogate from the powers of the High Court. For example, passing a bill that reduces the pecuniary jurisdiction of the High Court by raising the value of the suit that may be entertained by the High Court. This would be one method whereby the state legislature would diminish the authority of the High Court. Furthermore, a bill could also affect the subject matter jurisdiction of a High Court. For example, in enacting any measure under any of the entries contained in List 2, say debt cancellation, it would be open for the provinces or states to say that the decree made by any such court or board shall be final and conclusive, and that the High Court should not have any jurisdiction in the matter at all. In light of such possibilities, it was felt that the second proviso to draft Article 175 must be added. Para 82. It was the opinion of Dr. B.R. Ambedkar that any such bill or act as illustrated above would amount to a derogation from the authority that the Constitution confers or intends to confer upon the High Court. This is why it was felt necessary that before such a law becomes final, the President must be given an opportunity to examine whether such a law should be permitted to take effect or not. Such a shield was considered imperative, keeping in mind the important constitutional position that the High Courts hold in adjudicating disputes. Dr. B.R. Ambedkar had emphasized on the importance of the second proviso as follows. Quote, I therefore submit that in view of the fact that the High Court is such an important institution intended by the Constitution to adjudicate between the legislature and the executive and between citizen and citizen, such a power given to the President is a very necessary power to maintain an important institution which has been created by the Constitution. That is the purpose for which this amendment is being introduced. End of quote. Section E, Article 200 of the Constitution, developments post the commencement of the Constitution. A poem quoted, a poem by Robert Williams Service quoted here. If we could roll back history a century, let's say, and start from there, I am sure that we would find things as today, in all creation's cosmic range, no vestige of a change. End of quote. Para 83. We are tempted to preface this part of our judgment with the enlightening words of Robert Williams Service, keeping in mind the history of our country, which has been fraught with instances of friction in the federal polity from its inception, with the governor occupying the center stage in this ongoing saga. Para 84. As the democratic polity of the country unfolded post independence, the predominance of a single party at the union and provincial level gave way to emergence of new political factions and regional parties. As a consequence, the position of the governor, which had mostly been latent during the era of single party dominance, started to assume importance. Allegations also came to be leveled by a number of state governments that the governor in a number of states was acting as an agent of the central government, and the objectivity that was expected of the governor was not being displayed, more particularly when it came to reservation of bills for the consideration of the president or recommendation for the imposition of emergency under Article 356. In light of the aforesaid, certain commissions came to be constituted, which submitted their reports after undertaking exhaustive analysis of the working of the constitutional machinery prescribed for center state relations. One of the key foci of these reports was the working of Articles 200 and 201 of the Constitution, respectively, and the scope of exercise of discretion by the governors, which we deem appropriate to discuss hereinafter. Section 1, First Administrative Reforms Commission, 1966. Para 85. The First Administrative Reforms Commission, or the ARC, was established in January 1966 by a resolution of the Ministry of Home Affairs to examine the public administration of the country and make recommendations for reform and reorganization where necessary. An aspect of this exercise was the examination of center state relations, particularly with respect to the need for national integration and for maintaining efficient standards of administration throughout the country. Para 86. While examining the various facets of center state relations, the Commission found it apposite to discuss the role of the governor in the political context which existed back then. Taking note of the skirmishes between the state governments and governors, the Commission was of the view that the governor's office ceased to be merely ornamental and ceremonial. This changed role demanded a scrutiny of the discretionary powers of the governor. Para 87. As the discretionary powers of the governor affect some of the vital issues in the functioning of democratic governments in the states, the ARC underscores the importance of evolving guidelines to enable the exercise of such discretionary powers for the purpose of preserving and protecting democratic values. It was noted that such guidelines would serve the purpose of securing uniformity in action and eliminate all suspicions of partisanship and arbitrariness. Para 88. The ARC therefore recommended the following. Quote, Recommendation 9. We recommend Guidelines on the manner in which discretionary powers should be exercised by the governors should be formulated by the Interstate Council and on acceptance by the Union issued in the name of the President. They should be placed before both houses of Parliament. End of quote. Para 89. However, no such guidelines have been formulated by the Interstate Council till date, and none of the commissions on center state relations constituted thereafter made any recommendations on the issuance of guidelines for exercise of discretion by the governor. Section 2. Rajamannar Commission 1971. Paragraph 90. The Rajamannar Commission was set up by the government of Tamil Nadu in 1969 under the chairmanship of Dr. P.V. Rajamannar to look into the question regarding the relationship that should subsist between the center and states in a federal setup. The Commission noted that in the changed political circumstances, there can be no dispute regarding the fact that the governors have a positive role to play in the stability and progress of states. This requires that the authority of the governor should be clearly spelt out, and the governors should no longer consider themselves to be instruments of the center under compulsion to act on its directions and in its political interests. Para 91. One of the questions on which the Commission addressed itself was whether the Constitution provides for the exercise of any power by the Governor in his discretion, that is, whether the Governor could exercise any of his functions without consulting the Ministry or contrary to the aid and advice tendered by the Council of Ministers. Para 92. To answer this question, the Commission adverted to the history of the making of the Constitution and concluded that the Constitution does not provide for the issue of any instructions to the Governor, nor does it vest any discretionary powers in express terms in the Governor, except in relation to certain specified matters. While referring to certain judicial pronouncements of this court as well as Granville Austin's seminal work on the Indian Constitution, the Commission opined that the discretion of the Governor must be limited to those matters in respect of which there are express provisions in the Constitution. The relevant portion of the report is reproduced below. Number 6. Quote, the question as to the discretionary functions of the governor was considered by the Supreme Court in Ram Javaya versus State of Punjab, AIR 1955, SC 549 at page 556. The Supreme Court held that the governors were constitutional heads of the executive and that real executive power was vested in the Council of Ministers. A similar view has been expressed by the Supreme Court in T.M. Kannian versus ITO Pondicherry, AIR 1968, SC 687. Again, Granville Austin in his book The Indian Constitution, Cornerstone of a Nation, has categorically stated that the governor occupies the same position as the English monarch and that the governor has to act in accordance with the advice of his cabinet in all matters. To place the matter beyond doubt, Article 163, Clause 1 may be modified, making it clear that the reference to discretion is only in relation to the matters in respect of which there are express provisions. Example, Assam. End of quote. Emphasis supplied. Para 93. The Commission observed that while exercising his functions, the governor should not be under any pressure from an external authority. To explain the position of discretionary powers of the governor, the Commission referred to the speech of the former Vice President of India, Shri G.S. Pathak, which reads thus. Quote, he is the constitutional head of the state to which he is appointed, and in that capacity, he is bound by the advice of the Council of Ministers of the state, except in the sphere where he is required by the Constitution expressly or impliedly to exercise his discretion. In the sphere in which he is bound by the advice of the Council of Ministers, for obvious reasons, he must be independent of the center. Emphasis beginning. There may be cases where the advice of the center may clash with the advice of the State Council of Ministers. In the sphere in which he is required by the Constitution to exercise his discretion, it is obvious again that it is his discretion and not that of any other authority, and therefore his discretion cannot be controlled or interfered with by the center. End of quote. Emphasis supplied. Para 94. However, In the same vein, it was also noted that the governor has to function in a dual capacity as number one, the appointee of the central government, and number two, the constitutional head of the state. This is because the central government retains the power to appoint and remove the governor. Therefore, the governor cannot but look to the central government for guidance in the discharge of his duties. Para 95. The Commission was of the opinion that it is necessary to indicate at least a broad outline of the principles that should guide the Governor in the exercise of discretion, if any, vested in him. It was observed that the evolution of rules and guidelines in this respect is especially important in order to reconcile the actions of the Governor in his capacity as an agent of the center and the head of the state executive. Para 96. Having discussed the discretion of the governor in matters of constitutional decision making at length, the Commission recommended that a specific provision should be inserted in the Constitution to enable the President to issue instruments of instructions to the governors, laying down guidelines or principles with reference to which the governor should act, including the occasions for the exercise of discretionary powers. Section 3. Sarkaria Commission. Para 97. In June 1983, the central government, headed by the former Prime Minister of India, Mrs. Indira Gandhi, formally constituted a commission to examine and review the working of the arrangements between the Union and states in regard to powers, functions, and responsibilities in all spheres and to recommend such changes or other measures as may be deemed appropriate. The said commission was formed under the chairmanship of a former judge of this court, Justice R.S. Sarkaria, and hence came to be known as the Sarkaria Commission. Para 98. The Sarkaria Commission was enjoined with the task of reviewing the center-state relationship and consider the importance of unity and integrity of the country for promoting the welfare of the people. One of the facets of such review was to discuss the scope of the role of the governor and its impact on the federal polity of India. Para 99. For a number of years after the independence of India, the political scene was dominated by a single party and there was little occasion for strife between the central and state governments. The role of the governor therefore remained latent. However, post 1967, the emergence of new regional political parties led to a discord between the central government and those state governments that came to be led by such new regional parties. These developments engendered political instability in several states, as a result of which the governors were called upon to exercise their discretionary powers more frequently, particularly in recommending President's rule and in reserving state bills for the consideration of the President. Para 100. The role of the governor in giving assent to state bills, withholding assent therefrom, or reserving such bills for the consideration of the President thus assumed importance. By virtue of Articles 200 and 201 of the Constitution, respectively, the office of governor became a major stakeholder for the maintenance of a cordial relationship between the central and state governments. The Sarkaria Commission was, therefore, tasked with providing recommendations regarding the interpretation of the said articles and amendments therein to strengthen the federal polity of India. Paragraph 101. To the limited extent of studying the issues arising from the exercise of powers under Articles 200 and 201 respectively, the Commission addressed itself on the following broad points. Number 1. Scope of governor's discretion under Article 200. Number 2. Interplay of Articles 200 and T54 respectively of the Constitution. Number 3. Scope of Union Executive's discretion under Article 201. Number 4. Impropriety of conditional assent by the President. Number 5. Essentials for a reference of state bills to the President for his consideration. Number 6. Delays in disposal of state bills. Number 7. Withholding of assent by the President. Para 102. A discussion of the recommendation of the Commission in this regard would be beneficial to our examination of Articles 200 and 201 respectively and the role of the Governor in the contemporary federal polity. Item A. Scope of Governor's discretion under Article 200. Para 103. The Commission observed that the rule is that the Governor shall perform his functions on the aid and advice of the Council of Ministers of the state, and the exercise of discretionary powers by him is the exception. The Commission envisaged that discretionary powers of reservation of a bill under Article 200 should be exercised by the Governor only in rare cases where a bill is patently unconstitutional in his opinion. However, the Governor should not act contrary to the aid and advice of the Council of Ministers merely because he, in his personal capacity, does not favor the policy embodied in the bill. The relevant observations of the Commission are reproduced below. Quote 5.6.13. We are therefore of the view that number 1. Normally, in the discharge of the functions under Article 200, the Governor must abide by the advice of his Council of Ministers. However, in rare and exceptional case, he may act in the exercise of his discretion where he is of opinion that the provisions of the bill are patently unconstitutional, such as where the subject matter of the bill is ex facie beyond the legislative competence of the state legislature, or where its provisions manifestly derogate from the scheme and framework of the Constitution so as to endanger the sovereignty, unity, and integrity of the nation, or clearly violate fundamental rights or transgress other constitutional limitations and provisions. Item 2. In dealing with a state bill presented to him under Article 200, the Governor should not act contrary to the advice of his Council of Ministers merely because personally he does not like the policy embodied in the bill. End of quote. 104. According to the according to the Commission, the scheme of the Constitution indicates that the Governor's opinion at best is persuasive. The Governor cannot, in any circumstance, exercise dictatorial powers to override or veto the decisions or proposals of his Council of Ministers. The scope of discretionary powers should be construed in the context of a parliamentary democracy with a responsible government. In such a form of government, the role of a formal head of the state cannot be enlarged at the cost of the real executive, which enjoys the confidence of the people as it is responsible to the state legislature. Para 105. Discretion in exercise of powers under Article 200, therefore, should be dictated by reason, actuated by good faith, and tempered by caution. Discretionary functions should be performed in public interest and cannot be discharged at the dictation of any outside authority unless so authorized by and under the Constitution. Para 106. While addressing suggestions of some state governments that the discretionary powers of the governor must be curtailed or removed as it presents a potential threat to the autonomy of the states, the Commission observed that the makers of the Constitution advisedly refrained from putting such discretionary powers in a straitjacket rigid definition. It noted that the Constitution is ever evolving and the ways in which its provisions and principles may be tampered with or circumvented cannot be foreseen. Therefore, the office of the governor should be afforded enough flexibility to react in any situation, and his discretion to approach a matter cannot be predetermined. Item B. Interplay of Articles 200 and 254 respectively of the Constitution. Para 107. Article 246, Clause 2 endows the Parliament as well as the state legislatures with the competence to legislate on entries under List 3, that is the concurrent list. The provision under Article 254 is appurtenant to the concurrent exercise of legislative competence by the Parliament and state legislature insofar as there is any inconsistency or repugnancy between the laws of the respective legislatures. Para 108. Article 254, Section 1 saves the power of the state legislatures to make laws with respect to matters in the concurrent list from being automatically superseded by the operation of the doctrine of repugnancy. Article 254, Section 2 allows a law enacted by the state legislature and repugnant to the central law on the same subject matter to operate and prevail in that state provided that state law receives the assent of the President. Para 109. The Commission highlighted that Clause 2 of Article 254 is applicable only when the following two conditions are cumulatively met. Item A. There is a valid union law on the same subject matter occupying the same field in the concurrent list to which the state legislation relates. Item B. The state legislation is repugnant to the union law. That is to say, there is a direct conflict between the provisions of the two laws, or the union law is intended to be an exhaustive code on the subject matter in question. It is upon satisfaction of both these conditions that the governor can reserve a bill for presidential consideration under Article 254, Clause 2. Para 110. It was noted by the Commission that the assent by the President to the state bills had been withheld on certain occasions on the ground that the Union was contemplating a more comprehensive legislation on the same subject matter. However, withholding of assent on such a premise at the level of the Union may unnecessarily delay or defeat the measures sought to be taken by the state legislature. Since the Parliament retains the power to amend, vary, or repeal such a state legislation, even after its enactment, by passing a subsequent law inconsistent therewith, the Commission recommended that presidential assent should not ordinarily be withheld on the ground that the Union is contemplating a comprehensive law in future on the same subject matter. Section C. Scope of Union Executive's discretion under Article 201. As per the report of the Commission, a state bill, once reserved for the consideration of the President upon the aid and advice of the Council of Ministers, is made subject to the procedure prescribed under Article 201, and the Union Executive is entitled to examine it from all angles such as inter alia, conformity to legislative or executive policy of the Union, harmony with the scheme and provisions of the Constitution, wires of the bill, etc. Para 112. On the question of the Union Executive's discretion to withhold assent to a state bill on the ground of non-conformity with its policy, the Commission sounded a note of caution, saying that policy considerations should not ordinarily be treated as a valid ground for withholding presidential assent. Article 201 confers supervisory powers on the Union Executive to enable it to secure a broad uniformity across central and state legislations in the interests of the social and economic unity of the country. However, the said provision cannot act as a measure for the Union Executive to bring to a grinding halt a state bill by withholding assent thereto if such a bill does not conform to its policy in general. Para 113. Further, the Union Executive is required to exercise utmost caution, circumspection, and restraint in the exercise of supervisory powers under Article 201, especially in respect of the bills on subject matters that fall within the state list. In this regard, the Commission recommended that, as a matter of convention, the President should not withhold assent only on consideration of policy differences on matters relating in pith and substance to the state list, except on the grounds of patent unconstitutionality. Para 114. The Commission did not make any specific prescription in respect of Article 143 of the Constitution, which enables the President and by extension the Union Council of Ministers to seek the opinion of the Supreme Court in respect of bills which may be deemed to be unconstitutional, and left the decision up to the President to make such a reference in appropriate cases. Section D. Impropriety of conditional assent by the President. Para 115. The Commission noted that the scheme of the Constitution providing for reservation of state legislations for the consideration and assent of the President is intended to subserve the broad purpose of cooperative federalism in the realm of the Union-state legislative relations. Therefore, the practice of according assent to a state bill by the President on the reciprocal assurance that the changes suggested by him or the Union Executive will be carried out by way of an ordinance was not considered to be ideal, especially when there exists a constitutional remedy under the proviso to Article 201 itself. Para 116. Since conditional assent may become a tool for the center to dictate its policies to the states by attaching conditions to presidential assent, the Commission, in cognizance of the impropriety of such a practice, recommended that in cases where the union government is of the opinion that some amendments to a state bill are essential before it becomes a law, such bill should be returned through the governor to the state legislature for reconsideration in terms of the proviso to Article 201. Section E. Essentials for a reference of state bills to the President for his consideration. Para 117. The Commission, cognizant of the misgivings and irritations in Union State relations due to delays in the process of securing presidential assent, recommended that the procedure of making a reference to the President by the state government through the Governor and the consideration thereof by the Union government must be streamlined. It was also endorsed that the governments at both the center and state level may benefit from a prior consultation at the stage of drafting of the bill itself and prescribing time limits for disposal which ought to be made convention and practice. Para 118. As regards the suggestion of streamlining the procedures involved in reserving a state bill for consideration of the President, the Commission recommended that every reference from the state should be complete and clearly established. Such reference should set out precise material facts, points for consideration, and the reason for making a reference to the President. Accordingly, the Commission recommended the following information to be necessarily provided for ensuring that the reference to the President is self-contained. Quote 5.15.1. To facilitate its speedy examination by the Union Executive, every reference of a state bill from the state should be self-contained, setting out precisely the material facts, points for consideration, and the ground on which reference has been made. It should contain information on the following points. Item A. Emphasis added. The relevant provisions of the Constitution attracted are applicable with reasons. Item B. If the reference is made under Article 254, Clause 2, clear identification of the provisions of the bill which are considered repugnant to or inconsistent with the specific provisions of a union law or an existing law. Item C. Urgency, if any, of passing the law within a certain time limit. Item D. A clear statement that the bill is being reserved as per the advice of the Council of Ministers or in the exercise of his discretion by the Governor with reasons for the same. Item E. A lucid explanatory note on the intended policy behind the legislation instead of merely referring to the objects and reasons of the bill. Item F. An indication whether the bill was sent for prior scrutiny of the Union government and if so, deviations, if any, from the prior reference. End of quote. Emphasis applied. Section F. Delays in disposal of state bills. 119. The question whether there was a requirement of introducing time limits in Article 201 was necessary or not was also looked into by the Commission. It was reiterated that streamlining the procedure of reserving a state bill for presidential consideration and enabling a mechanism for high-level discussions between the union and state at the stage of drafting such bill may effectively reduce procedural delays at the level of the union government. Nevertheless, it was recommended that the union and state governments should adopt definite timelines for processing state bills and disposing of their references to the President. Para 120. With regard to prescription of such timelines, the Commission proposed the following timelines to be treated as salutary conventions. Table. Column 1, serial number. Column 2, stage of the bill. Column 3, proposed timeline. Item 1. Reserving the bill for consideration of the President by the Governor under Article 200 on the aid and advice of the State Council of Ministers. Proposed timeline. Immediately upon presentation of the bill to the Governor. Item 2. Stage of the bill. Reserving the bill for consideration of the President by the Governor under Article 200 in exercise of his discretion in exceptional circumstances. Proposed timeline. Within 1 month from the date on which the bill is presented to the Governor. Item 3. Decision on the bill by the President under Article 201 in case the proviso to Article 201 is not being exercised. Timeline. within 4 months from the date on which the reference is received by the Union Government. Item 4. Returning the bill for consideration of the state legislature in case the proviso to Article 201 is exercised by the President. Timeline. Within 2 months from the date on which the original reference is received by the Union Government. Item 5. Stage. Decision on the bill by the President once received with clarifications from the state legislature under proviso to Article 201. Timeline. Within 4 months of the date on which the reconsidered bill is received by the Union Government. Para 121. With a view to ensure that the timelines so suggested are not frustrated by lack of clarity and comprehensiveness in a reference, the Commission underscored the importance of self-contained communication by the President to the state legislature for clarification or reconsideration of the bill. It was emphasized that clarifications to be sought by way of the proviso to Article 201 should not be piecemeal. Para 122. While the Commission noted the significance of clear timelines for the exercise of powers under Articles 200 and 201 respectively, it did not recommend any amendments to the said articles for introducing concrete time periods within the constitutional scheme and left its recommendations in this regard at the stage of conventions only. Section G. Withholding of assent by the President. Para 123. As regards the withholding of presidential assent, the Commission laid great emphasis that the Union Government ought to communicate to the State Government the reasons therefor. It was noted that the Union Government should enter into the practice of discussing the issues present in the bill with the State Government and make an effort to present its point of view to the State Government with reasons. Section H. Recommendations given by the Commission. Para 124. Before concluding the discussion on the aspect of reservation of bills by the Governor for consideration of the President, the Commission noted that needless reservation of bills should be avoided. The constitutional scheme does not envisage indiscriminate reservation of bills, especially when it is being done in his discretion, as the same would be subversive of the federal principle and the supremacy of the state legislature. Para 125. The Commission classified state bills to be reserved for the consideration of the President as follows. Quote 5.1.5. State bills reserved for President's consideration under the Constitution may be classified as follows. Item 1. Bills which must be preserved for President's consideration. In this category come bills. Number 1, which so derogate from the powers of the High Court as to endanger the position which that court is by this Constitution designed to fill. Second, proviso to Article 200. Item 2, which relate to imposition of taxes on water or electricity in certain cases and attract the provisions of Clause 2 of Article 288. And Item 3, which fall within Clause 4, Section A, subsection 2 of Article 360 during a financial emergency. Section 2. Bills which may be reserved for President's consideration and assent for specific purposes. Item 1. To secure immunity from operation of Articles 14 and 19. These are bills for Item A, acquisition of estates, etc. First, proviso to Article 31A of 1. Item B, giving effect to directive principles of state policy, proviso to Article 31C. Item 2, a bill relating to a subject enumerated in the concurrent list to ensure operation of its provisions despite their repugnancy to a union law or an existing law by securing President's assent in terms of Article 254, Clause 2. Item 3. Legislation imposing restrictions on trade and commerce requiring presidential sanction under the proviso to Article 304, Clause B, read with Article 255. Section 3. Emphasis added. Bills which may not specifically fall under any of the above categories yet may be reserved by the Governor for President's consideration under Article 200. End of quote. Emphasis supplied. Para 126. The Commission recommended that bills should be reserved only if required for specific purposes, falling in the first two classes as extracted herein above. Section 4. Punchi Commission. Para 127. Another commission on center-state relations was constituted by the Government of India in 2007 under the chairmanship of Justice Madan Mohan Punchi, the former Chief Justice of India. The commission was tasked with the mandate of reviewing the existing arrangements between the Union and states as per the Constitution of India in regard to powers, functions, and responsibilities in all spheres, including legislative relations, administrative relations, role of governors, emergency provisions, etc., and recommending such changes as may be appropriate, keeping in view practical difficulties, growing challenges of ensuring good governance, and the need for strengthening the unity and integrity of the country. Para 128. The Commission, inter alia, looked at the original scheme of the center-state relations as laid down by the Constitution, examined the friction points in the working thereof, and reviewed the adequacy of the constitutional arrangements for promoting social welfare and good governance. One aspect of this study involved looking minutely into the role of the governor in the federal polity of India. The commission noted that the role of the governor became important as he had to balance the political considerations between the center and state and be as impartial as possible. Para 129. However, as regional political powers grew at the state level, the role of the governor came to be a point of contention between the center and states, with the latter leveling allegations of partiality and lack of objectivity in exercise of the governor's discretionary powers. As a result, the Commission was enjoined with the task of providing recommendations for better working of the office of the Governor. Item A. Role of the Governor. Para 130. The Commission observed that the nature and scope of rights and powers of the Governor should be understood in the context of a cabinet system of government. Under such system, the Governor performs a multifaceted role. First, as constitutional head of the state, he has a right to be consulted, to warn and encourage. In performance of this role, the constitutional makers ideated the office of governor to perform the role of a friend, philosopher, and guide to his council of ministers. Secondly, the governor functions as a sentinel of the constitution and acts as the union's representative in the state. As observed by this court in Rameshwar Prasad and others versus Union of India reported in 2006, to SCC 1, the governor discharges dual responsibility to the union and state. Para 131. Further, the Constitution affords the governor only a persuasive role and not dictatorial powers to override or veto the decisions or proposals of his Council of Ministers. The Commission observed that the governor, at best, has powers of giving advice or counseling for further reflection of the decision taken by the Council of Ministers. The governor only flags a need for caution for the purpose of bridging the understanding between the government and opposition if there are different governments at the central and state level. Para 132. The governor is not amenable to the directions of the union government, nor does the constitution make him accountable to the center for the manner in which he carries out his functions and duties. The office of governor is an independent constitutional office. The governor, by virtue of Article 163, however, is bound by the aid and advice of the State Council of Ministers. Therefore, in the event of a conflict between the aid and advice of the State Council of Ministers and the dictates of the central government, the scheme of the Constitution indicates that the governor must adhere to the former. Para 133. With the broad tenets of the role of the governor under the constitutional scheme, the Commission, while appraising the existing framework of center-state relations, observed that a major point of friction between the center and states is the power of the governor to reserve any state bill for the consideration of the president, sometimes even for an indefinite period. Section B. Discretionary powers of the governor. Para 134. Upon a perusal of Article 163, Clause 2, the Commission was of the view that the said provision gives the impression that the governor has a wide and undefined area of discretionary powers. However, the scope of the discretionary powers of the governor has to be narrowly construed. The language of Article 163, Clause 2 cannot be taken to mean that the governor has a generally sorry has a general discretionary power to act against the aid and advice of the Council of Ministers. Para 135. In continuation to the Sarkaria Commission's views on the question of discretionary powers of the governor, the Punchi Commission report also asserts that the area for the exercise of discretion is limited, and even in this limited area, the governor's choice of action should neither be nor appear to be arbitrary or fanciful. It must be a choice dictated by reason, actuated by good faith, and tempered with caution. Para 136. The Commission further emphasized the necessity of prescribing time limits for the exercise of powers under Articles 200 and 201 respectively, in order to ensure that discretionary powers are not exercised by the Governor or the President in a manner that undermines the state legislature and the will of the people. Section C. Expediency in disposal of bills. Timelines suggested by the report of the Commission. Para 137. The Commission suggested that definite timelines ought to be adopted as salutary conventions for the Governor to either provide assent or reserve the bill for the consideration of the President. Similarly, there should be a time limit for the President to take a decision on the state bill under Article 201 of the Constitution. The Commission was of the view that concrete timelines are sine qua non for the exercise of powers under Articles 200 and 201 respectively, so as to avoid dissensions between the central and state governments. Para 138. The Commission noted that the substantive part of Article 200 does not stipulate time period within which the Governor has to either assent, withhold assent, or reserve the bill for presidential consideration. The requirement of expediency is incumbent upon the Governor only when he decides to return the bill to the state legislature for reconsideration. The same was considered to be evident from the expression as soon as possible. Para 139. The Commission noted that while the expression as soon as possible is mentioned in Article 200, albeit only in the first proviso thereof, there is no such compulsion on the President under Article 201. As a result, the President of the Union Government may kill the bill by not taking a decision on the same, sometimes for the entire duration of the state legislature. This increases the scope for abuse of discretion by the Union Government based on political considerations, particularly when the ruling party in the state concerned is different from the one enjoying power at the Union level. The lack of a reasonable timeline allows the executive fiat to make inroads into the legislative power of the state, thereby thwarting the democratic will of the state legislature. Such invasion of the powers of the state legislature by the Union executive is questionable in the context of basic features of the Constitution. Therefore, the Commission suggested that a period of 6 months should be prescribed in Article 201 for the President to decide on assenting or withholding assent to a bill reserved for consideration of the President. In case the President, on the aid and advice of the Union Council of Ministers, is unable to give assent to a state bill under Article 201, it is desirable for him to make a reference to the Supreme Court under Article 143 for an opinion. Such reference should be done as a matter of practice in order to avoid allegations of political bias while securing the dignity and authority of the state legislature. Section D. Recommendations. Para 141. Having considered the challenges in the exercise of powers under Articles 200 and 201 respectively, the Commission reiterated the recommendations of the National Commission to review the working of the Constitution, NCRWC, which are reproduced herein below. Quote, after considering the suggestions given by the Sarkaria Commission, the National Commission to review the working of the Constitution gave the following recommendations. Item A. Emphasis added. Prescribe a time limit, say a period of 4 months, within which the Governor should take a decision whether to grant assent or to reserve it for the consideration of the President. Item B. Delete the words or that he withholds assent therefrom. Emphasis beginning. In other words, the power to withhold assent conferred upon the governor by Article 200 should be done away with. Item C. If the bill is reserved for the consideration of the President, there should be a time limit, say of 3 months, within which the President should take a decision whether to accord his assent or to direct the Governor to return it to the state legislature or to seek the opinion of the Supreme Court regarding the constitutionality of the Act under Article 143, as it happened in the case of Kerala Education Bill in 1958. Item D. When the state legislature reconsiders and passes the bill with or without amendments after it is returned by the governor pursuant to the direction of the president should be bound to grant his assent. Item E. To provide that a money bill cannot be reserved by the governor for the consideration of the president. Item F. In the alternative, it may be more advisable to delete altogether the words in Article 200 empowering the governor to reserve a bill for the consideration. Sorry. A bill for the consideration of the President, except in the case contemplated by the second proviso to Article 200 and in cases where the Constitution requires him to do so. Such a course would not only strengthen the federal principle but would also do away with the anomalous situation whereunder a bill passed by the state legislature can be killed by the Union Council of Ministers by advising the President to withhold his assent thereto or just by cold storaging it. End of quote. Emphasis supplied. Para 142. The report of the Punchi Commission advocated for the immediate implementation of the above mentioned recommendations by way of a constitutional amendment. Section F. International jurisprudence on assent to bills. Para 143. The tenets of parliamentary democracy demand that while the head of state must act on the advice of ministers, the ministers in turn must uphold their responsibility to the people when providing that advice. Indeed, the very raison d'etre of a democratic government is to uphold the primacy of the parliament by ensuring executive accountability. This has been aptly put forth by Nicholas Barber, professor of constitutional law and theory at the Oxford University, in his work Can Royal Assent Be Refused on the Advice of the Prime Minister, wherein he argues, quote, the point of the Convention on Royal Assent is to uphold the primacy of the democratic element of the Constitution in the making of law. But just as it would be undemocratic to allow one person, the monarch, to veto legislation, so too it would be undemocratic to give this power to the Prime Minister. In short, when presented with a bill that has passed through Parliament in a proper manner, the duty of the monarch is to give assent, irrespective of the advice of her ministers. There is no room for discretion. On its best interpretation, this is what the convention requires. If the monarch were to accept the advice of her prime minister on this issue, she would be acting unconstitutionally. Section A. United Kingdom. Para 144. The position in the United Kingdom is that once a bill has passed through all parliamentary stages in both houses, it is poised for the conferment of royal assent. Historically, the sovereign granted assent to bills in person in the House of Lords, attended by the Lord Commissioners. This formal ceremony was known as the Royal Assent Ceremony. The Royal Assent Ceremony continued until 1967, when the British Parliament passed the Royal Assent Act, wherein the requirement of grant of assent in person by the monarch was made voluntary. Although granting assent is a personal prerogative of the monarch, yet it has long been an established convention that the monarch does not withhold it for a bill that has received approval from both houses. The process of royal assent comprises two stages. First, the signification of the royal assent to a bill via the Royal Sign Manual on letters patent issued under the Great Seal of the realm, and secondly, the communication of the King's assent to both houses of Parliament. In the United Kingdom, royal assent is regarded as a formality and has not been refused to a bill since Queen Anne's reign in 1707. Para 145. In Parliament of the UK, The procedure for obtaining royal assent begins with officials in the Public Bill Office of the House of Lords that manages and assists the processes relating to the House's consideration of public legislation. First, a list of bills is prepared by the Clerk of the Parliaments. Thereafter, once a date for royal assent has been set, all the bills approved by both houses are presented before the monarch for assent. In this regard, the monarch has no power to withhold assent to a bill, regardless of any instructions from the government or anyone else. In Scotland, a period of 4 weeks is allowed before a bill is presented to the Queen for assent, during which any legal objections may be raised. Para 146. The only ground on which assent may be withheld, that too solely on ministerial advice, is if the bill has failed to comply with mandatory procedural requirements or if there has been a change in government between the bill's approval and its presentation for assent. Section 4 of the Judicial Committee Act 1833 provides that a sovereign may refer a bill to the Judicial Committee of the Privy Council for an advisory opinion on whether such bill contravenes a fundamental constitutional principle. However, the position in the UK does not clarify whether the sovereign can initiate such a referral independently. Section B, Canada. Para 147. Canada's royal assent ceremony traces its origins to the United Kingdom. Traditionally, once a bill was passed in identical form by both the Senate and the House of Commons, the Governor General, as the Crown's representative, attended the Parliament to provide royal assent to such bill. In absence of the Governor General, a Justice of the Supreme Court of Canada, acting as deputy to the Governor General, is presented the bills for royal assent. The Governor General signs a declaration of royal assent witnessed by the Clerk of the Parliaments. Para 148. Section 3 of the Royal Assent Act 2002, Canada, provides that assent may be given in Parliament assembled or through a written declaration, provided it is witnessed by more than one member from each house. The Act stipulates that the royal assent must be given in the Senate chamber at least twice a year and for the first appropriation bill of each session of the Parliament. In all other cases, such assent may be granted by the Governor General or her deputy by written consent. At the provincial level, assent is given by the Lieutenant Governor, who is appointed by the Governor General. As per Section 57 of the Constitution Act 1867, when bills are reserved for Queen's pleasure, she acts upon ministerial advice rather than the advice of the Houses. Para 149. The Supreme Court of Canada, in reference re-amendment of the Constitution of Canada, reported in 1981 SCC Online Canada SC 77, recognized that by convention neither the Queen nor the Viceregal representative, whose equivalent is the Governor in India, may on their own refuse assent to a bill passed by both houses of the Parliament on the grounds of opposition to or disapproval of its policy. The relevant portion of the judgment in reference reads thus, quote, as a matter of law, the Queen or the Governor General or the Lieutenant Governor could refuse assent to every bill passed by both houses of Parliament or by a legislative assembly as the case may be. But by convention, they cannot of their own motion refuse to assent to any such bill on any ground, for instance, because they disapprove of the policy of the bill. We have here a conflict between a legal rule which creates a complete discretion and a conventional rule which completely neutralizes it. But conventions, like laws, are sometimes violated. And if this particular convention were violated and assent were improperly withheld, the courts would be bound to enforce the law, not the convention. They would refuse to recognize the validity of a vetoed bill. This is what happened in Gallant versus the King, a case in keeping with the classic case of Stockdale versus Hansard, where the English Court of Queen's Bench held that only the Queen and both houses of Parliament could make or unmake laws. The Lieutenant Governor who had withheld assent in Gallant apparently did so towards the end of his term of office. Had it been otherwise, it is not inconceivable that his withholding of assent might have produced a political crisis leading to his removal from office, which shows that if the remedy for a breach of a convention does not lie with the courts, still the breach is not necessarily without a remedy. The remedy lies with some other institutions of government. Furthermore, it is not a formal remedy and it may be administered with less certainty or regularity than it would be by a court. End of quote. Para 150. In Galati versus Governor General of Canada, reported in 2015 FC 91, the Federal Court of Canada was faced with the question of whether the grant of royal assent by the Governor General to the Strengthening Canadian Citizenship Act 2014 could be set aside by the court on the ground that enactment of the same was outside the legislative competence of the Parliament. It was contended by the applicants that the Governor General exceeded the scope of his discretion as well as his authority under the Royal Assent Act of Canada by assenting to the said bill. The federal court, however, dismissed the application and held that the Governor General's act of affixing royal assent to the bill was a legislative act. Therefore, the issue of whether the Governor General exceeded his constitutional authority in granting royal assent to the said bill was not justiciable. The relevant portion of the judgment is reproduced below for ready reference. Quote, the courts exercise a supervisory jurisdiction once a law has been enacted. Until that time, a court cannot review, enjoin, or otherwise engage in the legislative process unless asked by way of a reference framed under the relevant legislation. To conclude otherwise would blur the boundaries that necessarily separate the functions and roles of the legislature and the courts. To review the Governor General's act of granting royal assent as the applicant's request would conflate the constitutionally discrete roles of the judiciary and the legislature, affecting a radical amendment of the Constitution Act 1867 and the conventions which underlie our system of government, notably the right of Parliament to consider and pass legislation. The applicant's arguments turn this principle on its head. On the theory advanced, the judiciary would adjudicate on the constitutionality of proposed legislation before it became law. That line, once crossed, would have no limit. End of quote. Para 151. The views of the federal court in Galati quoted supra that the grant of royal assent by the Governor General was a legislative act and hence non-justiciable was in line with the view of the court in Gallant versus the King 1949 2 DLR 425, wherein it was noted that the Lieutenant Governor is a part of the legislature and the act of providing royal assent is also a legislative action. Section C, United States of America. Para 152. The Constitution of the United States, more particularly Article 1, Section 7, Clause 2 thereof, states that once a bill has been passed by the House of Representatives and the Senate, it must be presented to the President. If the President approves, he may sign the bill. Otherwise, he may return it with his objections for reconsideration. If, after reconsideration, 2/3 of both the houses passes the bill, it becomes law. Further, if the President does not sign a bill within 10 days of presenting the same, while Congress is in session, the bill automatically becomes law. Therefore, in this limited circumstance, the concept of pocket veto is not available to the President. However, if Congress adjourns while the bill is awaiting assent and the President does not sign the bill within 10 days, the bill does not become law. Section D, New Zealand. Para 153. The colonial legislative framework of New Zealand under the Constitution Act 1852 vested structured discretion in provincial authorities while maintaining the supremacy of the Crown. Section 27 of the Constitution Act 1852 stipulated that every bill passed by the Provincial Council must be presented to the superintendent, who was an elected head of each provincial council, for the assent of the governor, who was the representative of the monarch. The superintendent, in his discretion, could have either granted assent on behalf of the governor or withheld assent or reserved the bill for the governor's pleasure. For a bill to become law, superintendent had to signify governor's assent. Further, Her Majesty, with the advice of her Privy Council, could issue instructions to the governor to guide him in exercise of his powers to assent to, dissent from, or reserve bills for Her Majesty's pleasure. The governor was required to act in obedience to these instructions. Para 154. By the introduction of the Constitution Act 1986, the sovereign began to act on the advice of the Executive Council, which is the part of the executive branch of government. It states that a bill passed by the House of Representatives becomes law when the sovereign or the Governor General grants assent. Section 3 of the Act states that the power conferred on the Governor General are royal powers exercised on behalf of the sovereign. These powers may be exercised either by the sovereign in person or by the Governor General. Additionally, any reference in an act to the Governor General in Council also includes the sovereign acting with the advice and consent of the Executive Council. The Prime Minister designate is appointed as the Executive Councillor and he advises the Governor General to appoint other councillors. Section 3A removes any discretion of the sovereign or the Governor General, stating that they may exercise a power on the advice and with the consent of the Executive Council. Section E, Australia. Para 155. The structure of governance in Australia reflects a nuanced distribution of the Queen's powers through her representatives at both national and state levels. The Queen of Australia is the former head of state. At the national level, the Queen's powers and functions, qua the Government of Australia, are exercised by the Governor General of Australia. At the state level, her powers are exercised by the Governor of the state. As per Section 2, Subsection 1 of the Constitution Act 1889, the legislative powers were vested in the sovereign and exercised by her colonial governors, subject to the advice of legislators. At the national level, Governor General is not given ministerial advice on assent. The presiding officer of the House requests for assent, and the Attorney General provides a certificate to the Governor General regarding whether the bill needs to be reserved for the Queen's assent or regarding any corrections. Para 156. It is said that the role of the Governor General is to ensure due process, that the bill was passed in houses following the procedure. He is not concerned with the contents of the legislation as the act of the Governor General is executive. However, in the context of governor at state level, the Court of Appeal in Eastgate versus Rosoli reported in 1990-20 NSW LR 188 noted that while giving assent, the Australian state governor acts as a constituent part of the parliament. If a bill is reserved for Queen's pleasure, she acts upon the advice of Australian Commonwealth ministers. The power to refer bills back to Parliament can be exercised only upon ministerial advice. At the states, the parliamentary officers seek state governors' assent. Ordinarily, the state governors assent to bills without any ministerial advice. Only South Australia endeavours to provide executive advice to the governor. Section F, Ireland. Para 157. Ireland's constitutional order provides a unique provision enabling the President to refer bills to the Supreme Court for its view on the constitutionality of the bills. Article 26 of the Constitution of the Ireland confers a power on the President who, after consultation with the Council of State, may refer any bill to the Supreme Court for a decision on whether any provisions of the bill are repugnant to the Constitution. Such reference must be within 7 days from the presentation of the bill to the President. If the Supreme Court holds that any provision of the bill is repugnant to the Constitution, the President declines to sign such bill. Section G, Republic of Singapore. Para 158. The Constitution of Singapore establishes a structured framework for the exercise of presidential discretion, setting clear time limits for decision making while also ensuring safeguards against legislative overreach. Article 21A of the Constitution stipulates the general time limit for the President to exercise his discretionary powers. It provides that when the Constitution grants the President discretion in granting or refusing assent, concurrence, approval, or confirmation, he must signify his decision within the specified period after it is sought. The time period specified for granting assent ranges from 30 days to 6 weeks. However, it may be extended contingent upon any agreement between the President and the Cabinet. Para 159. Article 22H applies in cases where the bill or any provision seeks to curtail discretionary powers of the President. If within 30 days the President neither withholds assent nor refers the bill to the tribunal for its opinion on whether the bill curtails the President's discretionary powers, then the President is deemed to have assented. Even when the tribunal is of the opinion that the bill does not curtail the discretionary powers conferred on the President is still deemed to have assented. Section H, Democratic Socialist Republic of Sri Lanka. Para 160. The Constitution of Sri Lanka More particularly, Article 154H stipulates that upon the presentation of a statute enacted by the Provincial Council, the Governor shall either assent to it or return it for reconsideration as soon as possible. The Provincial Council may then pass the statute with or without amendments. If the statute is presented to the Governor again, he may reserve it for reference by the President to the Supreme Court within 1 month of its second time, seeking a determination as to whether it is consistent with the Constitution. If the Supreme Court holds the statute to be consistent, the Governor must grant consent. If it is held inconsistent, the Governor may withhold assent. It can be concluded that upon the first presentation of a bill, the Governor has only two options, granting assent or returning it for reconsideration. On the second presentation, the Governor may only reserve the bill, referring it to the President for submission to the Supreme Court. He does not have the discretion to withhold assent independently. Section I. Republic of Kiribati. Para 161. The constitutional framework of Kiribati is similar to the Democratic Socialist Republic of Sri Lanka. It provides powers to withhold assent only in exceptional situations. Section 66 of the Constitution of Kiribati allows the Berettinetenti, that is the head of the state and head of the government, to withhold assent to a bill only if he believes the bill to be inconsistent with the Constitution. In such a case, the bill is returned to the Parliament for amendment, and if it is presented again and the Berettinetenti still believes that the bill is inconsistent with the Constitution, he is required to refer it to the High Court for a declaration. If the court declares that the bill is not consistent with the Constitution, the Berettinetenti must grant assent forthwith. If the court declares the bill to be inconsistent, it is sent back to Parliament. The Constitution of Zimbabwe under Section 131 provides a time period of 21 days to either assent to the bill or refer it for reconsideration. Section J. Republic of Fiji. Para 162. The Constitution of Fiji 2013 also does not vest discretionary power in the President. While Section 53 of the Fiji Independence Order 1970 and Constitution of Fiji granted the Governor General the power to grant assent or withhold assent, the Constitution of Fiji 2013 removed any discretion on the part of the President. Section 48 of the Constitution stipulates that once a bill is passed, the Speaker must present it to the President for assent, which must be granted within 7 days. Otherwise, the bill is deemed to have received assent. Section K. Solomon Islands and Antigua and Barbuda. Para 163. Both the Solomon Islands and Antigua and Barbuda have constitutional provisions that mandate the Governor General to grant assent to bills passed by Parliament. In the Solomon Islands, Section 59, subsection 2 of the Constitution of the Solomon Islands provides that when a bill has been passed by the Parliament, it shall be presented to the Governor General, who shall assent to it forthwith on behalf of the head of the state. Whereas Section 52, subsection 2 of the Constitution of Antigua and Barbuda states that when a bill is presented to the Governor General for assent in accordance with this Constitution, he shall signify that he assents thereto. Section L. Islamic Republic of Pakistan. Para 164. In our neighboring country, Article 75 of the Constitution of the Islamic Republic of Pakistan provides that when a bill is presented to the President, he must either assent within 10 days or return it to Parliament with a request for reconsideration. If the bill is passed again by a majority, whether amended or not, the President must grant assent within 10 days, failing which it will be deemed to have received assent. Whereas Article 105 stipulates that the Governor shall act in accordance with the advice of the Cabinet or the Chief Minister. The Governor may, however, require the Cabinet or the Chief Minister to reconsider the advice. Following such reconsideration, the Governor must act in accordance with the advice tendered within 10 days. Section M. Federal Republic of Germany. Para 165. The legislative process in Germany is governed by both federal and state constitutional provisions. Article 76 of the Basic Law for the Federal Republic of Germany states that bills are to be introduced in Bundestag, house elected by the people, by the federal government, or by the Bundesrat or the Federal Council. The provision grants the Bundesrat a period of 6 weeks to comment on bills for federal government bills. The federal government submits the bills along with its views to the Bundestag within 6 weeks along with its reviews. Article 78 provides that a bill adopted by the Bundestag becomes the law if the Bundesrat consents to it. Laws enacted in accordance with the provisions of the Basic Law after being countersigned are certified by the Federal President. Furthermore, Section 60, Section 5, the Constitution of Berlin stipulates that the bills shall be signed by the President of the House of Representatives without delay and then promulgated by the governing mayor within 2 weeks. Section N. Italian Republic. Para 166. The legislative process in Italy is shaped by constitutional provisions that define the President's role in the promulgation of laws and the scope of legislative urgency. Article 73 of the Constitution of the Italian Republic mandates that laws be promulgated by the President within 1 month of their approval. However, if the chambers where the parliament consists of the Chamber of Deputies and the Senate of the Republic by a majority vote, declare a bill to be urgent, it shall be promulgated within the time specified by the bill itself. Article 74 empowers the President to request a new deliberation by means of a message stating the reasons for such a request. It is important to take note that if the chambers pass the bill once again, then the law must be promulgated. Section O. French Republic, para 167. In France, the promulgation of legislation is subject to defined constitutional timelines. Article 10 of the Constitution of October 4, 1958 stipulates that the President of the Republic must promulgate acts of Parliament within 15 days after the final passage of an act. It also empowers the President to request Parliament to reopen the debate on the Act or any specific sections thereof, and such a request for reopening of debate shall not be refused. Section P. Japan. Para 168. As per the Japanese constitutional framework, the Diet or the Parliament of Japan is the sole lawmaking organ of the state. Article 59 envisages that if a bill passed by the House of Representatives is rejected by the House of Councillors, it becomes a law when passed a second time by the House of Representatives by a two-thirds majority of the members present. Article 74 states that all laws and cabinet orders must be signed by the competent Minister of State and countersigned by the Prime Minister. Section G. Analysis. Okay, I think we will stop the video over here. I think it has run to several hours. And then I'll begin section G in next video.